All right. Wow, you really weren't kidding around when you requested this deep dive. You want to get a handle on the U.S. federal rules of evidence, huh?
Yeah, you sent us a whole stack of stuff.
Legal texts, case analysis, even a quiz. Ambitious.
It's great, though. It's clear you've already been giving this some thought.
Definitely.
Especially with those notes. I see you're questioning some things already.
Yeah, and that's what we're here for, right? To help sort through all this. Take this mountain of info and turn it into something you can actually use.
Yeah, for sure. And, I am really interested in some of the things you were questioning in your notes.
Oh, yeah.
Yeah, I mean, you're already thinking critically about this, which is fantastic.
So our mission today is to really distill this down to the essence of U.S. evidence law for you. We'll unpack the core principles, see how they play out in actual cases.
Yeah.
And by the end of this, I think you'll have the knowledge to navigate this whole complex world.
It's almost like you're getting a master class in the rules that determine what information a jury gets to see and hear.
Oh, interesting.
And how that impacts the outcome of a case.
Yeah, so that's pretty high stakes.
High stakes, exactly.
But before we jump into the nitty-gritty, let's set the stage. What exactly are the federal rules of evidence?
Right.
And why should anyone care?
Well, imagine a legal system with absolutely no rules about what evidence can be presented.
Oh, wow.
I mean,
chaos.
Total chaos, right.
Yeah.
So these rules are there to ensure fairness and reliability.
Okay.
They're the guardrails, really.
So they're kind of like the ground rules for any legal battle.
Yeah, exactly.
But, and this is where one of your notes comes in.
Right.
Do these rules apply to every legal situation or just trials?
That's a good question.
Yeah.
That's a really astute observation, actually.
Mm-hmm.
While trials are where these rules really take center stage, they actually have a much broader reach.
Okay.
So think grand jury investigations, bail hearings,
Okay.
even sentencing. The goal is consistency and fairness across the board.
You also had a question about the difference between grand juries and trial juries.
I saw that.
Which I'll admit can be a bit of a head scratcher.
Absolutely. And it's all about purpose.
Okay.
A grand jury, made up of 16 to 23 people, acts as a filter early on in a criminal case.
Interesting.
They review evidence presented by the prosecution.
Okay.
And if they believe there is probable cause, they'll issue what's called an indictment, which formally charges the defendant.
So it's kind of like a preliminary hearing?
Yeah.
Deciding if there's even enough evidence to go to trial.
Exactly.
Okay.
And here's where it gets interesting.
Okay.
The rules of evidence apply very strictly to trials, but grand juries have a little more leeway.
Oh, okay.
They can consider evidence that wouldn't be allowed at trial.
Why is that? It seems like kind of a double standard.
It all comes down to efficiency.
Okay.
Grand juries need to move quickly. They're sifting through mountains of information to decide if a case should proceed to trial or not. Plus, and this is important to remember, these proceedings are totally secret.
Oh, wow.
The defendant isn't even present. And that secrecy, it's there to protect someone from accusations that could turn out to be completely baseless.
Okay, so that makes sense.
Yeah.
So trials are super strict. Grand juries are more flexible.
Right.
Now, I see you included a quiz on which proceedings don't strictly follow the rules of evidence at all. Let's tackle that.
All right. Think of situations where speed and practicality are more important than strict adherence to the rules.
Okay.
Extradition, for example.
Okay.
It's all about getting someone who's accused of a crime to the correct jurisdiction.
Okay.
It's not about proving their guilt or innocence at that point.
So the focus is on process, making sure the right person ends up in the right place.
Precisely.
Okay.
Similarly, bail hearings, even sentencing proceedings, they often operate with a lot more flexibility.
Okay.
Judges, in these situations, they need to make decisions really quickly, weighing a whole bunch of factors without getting too bogged down in all the legal technicalities.
That raises kind of an interesting point.
Yeah.
Sometimes efficiency trumps strict legal process?
Yeah.
Do you think that's always a fair trade-off?
It's definitely a debate that legal scholars are always grappling with.
Yeah, I bet.
On one hand, we want a system that moves quickly.
Right.
One that doesn't drown in procedure.
Yeah.
But on the other hand, cutting corners can sometimes compromise individual rights.
Right.
So it's tough.
It's a delicate balance for sure.
Yeah.
Now, your notes indicate you're particularly interested in how scientific evidence is handled under these rules.
Right.
Especially given all the advancements in forensics and technology these days.
Absolutely. And that's a critical area.
Yeah.
It's one where the courts have had to evolve significantly.
I bet.
And the landmark cases here are what's known as the Daubert Trilogy.
Oh.
Okay, a set of 3 Supreme Court rulings that established a very high bar
Interesting.
for admitting scientific evidence.
Okay, Daubert trilogy sounds kind of intimidating.
Yeah,
Can you break that down for us?
absolutely.
Okay.
The Daubert standard essentially tasks judges with being what we call scientific gatekeepers.
Oh, okay.
It's about preventing junk science
Right.
from influencing a jury.
Okay.
And judges have to consider 3 key factors.
All right, so what are they?
First, reliability.
Okay.
Is the scientific theory or technique generally accepted by the scientific community? Has it been tested, validated?
So no, using some fringe theory that hasn't been proven.
Exactly.
Yeah.
Second, relevance.
Okay.
Does the scientific evidence actually relate to the facts of the case at hand?
Right.
Is it truly helpful in determining guilt or innocence?
So it can't just be some cool science experiment that's totally unrelated to the case.
Exactly.
Got it.
And third, there's what we call fit.
Okay.
The evidence has to logically connect to the specific issue at hand.
Interesting.
So it's not just about the science being good. It's about the science being applicable to this particular situation,
Right, right.
to this case.
So the Daubert trilogy is like a safeguard, ensuring that only reliable and relevant scientific evidence makes its way into the courtroom.
Right.
Now, you also had a question about attorney-client privilege,
Yeah.
which is something I think a lot of people are curious about.
Yeah, privilege, it's a cornerstone of our legal system. Certain communications are considered so sacred,
Yeah.
so essential to the functioning of the legal process,
Right.
that they're protected from disclosure,
Wow.
even if they might be relevant to a case.
So even if a piece of information could be the key to solving a crime or proving someone innocent, it might be completely off limits.
That's right. And it's not just attorney-client privilege.
Right.
We also have doctor-patient privilege,
Okay.
spousal privilege, and a few others.
Interesting.
And the rationale is that these relationships rely on trust and confidentiality, and that protecting these communications ultimately serves a greater good.
So if you tell your doctor something in confidence, they can't be forced to reveal that,
Exactly.
even if it's relevant to a lawsuit.
Exactly.
Wow.
And a crucial point here is that privilege applies across all stages of a case, not just at trial.
Okay.
It even applies before a lawsuit is filed.
Wow. Okay. Yeah. So privileges are all about keeping certain secrets safe.
Exactly.
You also highlighted some sections about amendments to the rules of evidence.
Right.
What's the significance there?
It's important to understand that these revisions generally focus on clarity,
Okay.
rather than overhauling existing decisions. It's about making the language more accessible and consistent,
Okay.
not necessarily changing the underlying principles.
Like a software update.
Yeah.
Improving the user interface without changing the actual code.
That's a great analogy.
Oh, okay.
Yeah, these amendments really reflect the legal system's ongoing effort to be more transparent and understandable.
Now, you were also curious about how the U.S. evidence rules compare to those used in other parts of the world.
I saw that.
Yeah, I'm always fascinated by how different legal systems approach these fundamental issues.
Yeah, that's where things get really interesting.
Okay.
The U.S. operates under what we call an adversarial system,
Okay.
where two sides present their cases and the judge acts as a neutral referee.
So like a legal boxing match.
In a sense, yes.
Oh,
Each side trying to land their punches.
yeah, right.
Now, contrast that with continental European systems,
Okay.
which are more what we call inquisitorial.
Inquisitorial, meaning the judge is more actively involved in the investigation.
Yeah.
Asking questions, digging for information.
Exactly. They might question witnesses directly, order investigations, and really play a much more active role in uncovering the truth.
Wow.
Yeah, a very different approach.
Yeah.
And it raises some fascinating questions.
Definitely big questions.
Yeah.
And we'll delve into those and more in just a moment.
Sounds good. Those are really excellent questions, and the answers aren't always clear-cut.
Right.
Both systems have their strengths and weaknesses.
Yeah.
The adversarial system, with its emphasis on due process and, presenting both sides, really prioritizes individual rights.
Yeah.
But some argue that this focus on winning
Right.
can sometimes overshadow the pursuit of truth.
And the inquisitorial system, with the judge leading the investigation, might be more efficient in uncovering the truth,
Right.
but potentially at the cost of those individual rights.
That's the real crux of the debate.
Yeah.
It really boils down to different values and priorities within each legal system.
Yeah.
And it's interesting to think about how those differences impact not only legal outcomes, but also societal perceptions of justice.
Oh, for sure.
Yeah.
Speaking of seeking truth,
Right.
we talked about how scientific evidence is vetted under the Daubert standard.
Right.
But what about something we see in every legal drama on TV?
Yeah.
Good old-fashioned eyewitness testimony. Oh, yeah. How do the rules of evidence address that?
Eyewitness testimony is a really interesting area
Mm-hmm.
because while it seems so straightforward,
Right.
it can be surprisingly unreliable.
Oh, really?
Our memories, you see, they are perfect recordings.
Oh, interesting.
They're influenced by stress, by bias, even the way questions are asked.
Wow. So even if you're absolutely certain you saw something,
Yeah.
your memory might not be accurate.
Exactly.
Wow.
And the federal rules of evidence recognize this fallibility.
Okay.
And they have rules regarding how eyewitness testimony can be presented and challenged in court.
So a good lawyer might question not only what an eyewitness saw, but also their opportunity to observe
Right.
their state of mind at the time,
Exactly.
even how their memory might have been influenced since the event.
Precisely. They might introduce evidence that contradicts the eyewitness account,
Oh, wow.
or bring in an expert to testify about the science of memory and its limitations.
That makes me think about all those cases where DNA evidence exonerated people who were convicted based on eyewitness testimony.
Mm-hmm.
It really highlights the importance of carefully scrutinizing all types of evidence.
It's a really stark reminder
Yeah.
that what appears convincing on the surface may not hold up under scrutiny.
Yeah.
Now, shifting gears a bit,
Okay.
I see you're curious about the concept of hearsay,
Yes.
which often gets confused with just simple gossip.
I have to admit, the term always makes me think of rumors and whispers.
Well, it is related to out-of-court statements,
Okay.
but in a more specific legal context.
Okay.
Hearsay is essentially an out-of-court statement offered in court to prove the truth
Mm-hmm.
of what the statement asserts.
So let's say someone told me John robbed the bank,
Yeah,
and I repeated that in court.
right.
That would be hearsay.
Exactly.
Okay.
Because you're not testifying about something you personally witnessed or heard,
Right.
but rather what someone else told you.
And that's generally not admissible in court.
Correct. And the main reason is that the person who actually made the statement
Yeah.
isn't in court to be cross-examined.
Oh, okay.
We can't test their credibility
Yeah.
or the accuracy of their statement.
That makes sense.
Yeah,
But there must be exceptions to this rule, right?
of course.
Otherwise, how could things like witness statements or
Mhm.
police reports ever be used in court?
You're absolutely right.
Okay.
The rules of evidence recognize that some types of out-of-court statements
Yeah.
are reliable enough to be admitted as evidence,
Okay.
but these exceptions are very specific and carefully defined.
Okay, so can you give us an example of a hearsay exception?
Certainly,
Oh,
statements made for the purpose of medical diagnosis or treatment.
okay.
Those are generally admissible.
Okay.
Even if a doctor is repeating what a patient told them,
Right.
it's considered reliable
Yeah.
because people are generally truthful when discussing their health.
Right. It's in their best interest to be honest with their doctor. What about other exceptions?
Another common one is what we call the business records exception.
Okay.
We generally trust that businesses keep accurate records of,
Right.
of their transactions.
Yeah. Yeah.
So a sales receipt, for example, could be admitted as evidence of a purchase,
Okay.
even though the cashier isn't there to testify.
So it's a balancing act
Yeah.
between excluding unreliable hearsay
Right.
and allowing certain types of out-of-court statements
Exactly.
that have a high degree of trustworthiness.
Precisely. And the rules go into a lot of detail about the requirements for each exception.
Yeah, I bet it can get pretty complex.
It can get quite complex.
Now, one last area I wanted to touch on is the role of the judge
Okay.
when it comes to these rules.
Yeah.
It seems like they have a lot of power to decide what evidence gets in,
Yeah.
what gets excluded.
Absolutely. The judge acts as a gatekeeper,
Mm-hmm.
ensuring that only evidence that meets the standards of the federal rules is presented to the jury.
Okay.
They have the authority to rule on admissibility, weighing factors like relevance, reliability, and potential prejudice.
So even if a lawyer thinks they have a smoking gun piece of evidence,
Oh, yeah.
the judge can say, nope, not admissible.
That's right. The judge might rule that the evidence is irrelevant to the case, unreliable, or what we call unfairly prejudicial,
Okay.
meaning it might sway the jury's emotions rather than their logical reasoning.
I imagine that leads to some pretty heated legal arguments.
You bet. Lawyers are always strategizing
Right.
about how to get evidence admitted,
Yeah.
how to challenge the other side's evidence,
Mm-hmm.
and ultimately how to persuade the judge to rule in their favor.
Yeah.
It's a constant back and forth, a
Right.
chess match within the larger legal battle.
It's fascinating to see how these rules shape not only the legal process itself,
Yeah.
but also the strategies that lawyers employ.
It really underscores how the federal rules of evidence are about so much more than just procedures.
Right.
They're about ensuring fairness, protecting individual rights, and ultimately striving for truth within the framework of our legal system.
We've covered a lot of ground here, from grand juries to hearsay exceptions to the judge's role as gatekeepers.
We have.
And we've seen how these rules strike a delicate balance between seeking truth and upholding individual rights.
It's a tension that's at the heart of any justice system.
Speaking of ongoing exploration, we're going to take just a moment, gather our thoughts.
Sounds good.
And when we return, we'll have some final takeaways from your deep dive and some key points to keep in mind as you continue to navigate this complex but crucial area of law.
Okay, so we're back. And wow, this deep dive into the federal rules of evidence has been quite a journey. We've covered so much, from grand juries and scientific evidence to all the nuances of hearsay. What stands out to you as the most significant aspect of these rules?
I think it's fascinating to see how these rules constantly try to balance these competing interests, right?
On one hand, we want the truth. We're trying to figure out, piece together what really happened.
Yeah.
But on the other hand, we have to protect individual rights and ensure fairness, even if it means leaving some evidence out.
Right.
So
that tension between truth-seeking and fairness really is a theme we've seen throughout this whole deep dive.
Oh, absolutely.
It seems like these rules are really a reflection of that struggle, to find the right balance.
Yeah, they are. And these rules aren't just some, abstract legal concepts.
Right.
They represent a very real effort, constantly ongoing, to balance the needs of the legal system with the pursuit of truth.
You've done a really incredible job of breaking down these complex concepts and showing us what they mean in the real world.
Well, thank you.
As you continue to explore this area of law, what key takeaway would you leave our listener with?
I'd encourage you to think about how these rules affect not only what happens in court, but also our broader understanding of truth and justice as a society. That's something worth thinking about as you, look at specific cases and arguments and stuff.
It's a great point. The federal rules of evidence aren't just about procedures, right?
Right.
They really reflect our values as a society.
Yeah.
How we understand fairness.
Yeah.
And really our commitment to having just a legal system.
Exactly.
And it's a system that works.
And remember, they're constantly evolving.
That's true.
Shaped by court decisions, societal changes, even, technology. So stay curious and keep learning.
I think that's a perfect note to end on. The legal world never stands still.
It doesn't.
And the federal rules of evidence are leading the way. Now, for our listener, if you're ready to really go deep, I highly recommend looking closer at those case summaries you sent.
Yeah, good idea.
Seeing how it all plays out in real life is really eye-opening.
Yeah, and don't be afraid to question what you think you know as you learn. There are always exceptions and nuances, always more to uncover. That's what makes this all so interesting.
Couldn't have said it better myself. Thanks for joining us on this deep dive into the federal rules of evidence. Until next time, keep those legal minds engaged